this court concluded that the urgency relied on was self-created, and the explanation furnished for the delay in approaching this court was not satisfactory. But the unsatisfactory explanation falls short of gross negligence or bad faith, which would warrant a personal costs order. What remains for determination is whether Sassa and its CEO, in her official capacity, pay costs of the application. Were it not for the fact that the refusal to extend the period of suspension would have severely prejudiced innocent grant recipients, the application could have been dismissed. Consequently, the applicants must bear the costs of the application. In the result, the following order is made. South African Social Security Agency and the Chief Executive Officer, in her official capacity, are ordered to pay costs of the application jointly and severally, and such costs shall include costs of two counsel.
All right, for more on the story now, we're joined by our reporter Erin Bates, who joins us live from the Constitutional Court. So, Erin, the Constitutional Court weighing in on the fact that, in fact, it's been something that a lot of people have said, commenting on the issues around Sassa and CBS, that it was a self-created disaster.
Yes, that Sassa and its then acting CEO, Bhengu, ran to the court, you could say, in early 2018, saying they needed this extension for the dispersion of cash social grants, which then reached about 2.8 million people, and they needed this permission from the court to extend the CPS contract for those grants. But the court saying today, in a very harshly worded judgment, that this crisis was self-created. And so they have imposed, you could argue, a kind of penalty, but not in a personal capacity for Bhengu or even the Minister Batabile Dlamini, who came off scot-free in this matter, but for Bhengu in a professional capacity as then acting CEO and for Sassa.
So what does that mean in terms of Bhengu being held responsible in her professional capacity? Who foots the bill here?
Well, government fits the bill, and by government you could argue the people of South Africa, because we, of course, through our taxes and the like, pay money into government's coffers. And so Bhengu here is not going to pay out of her own budget, her own pocket. Sassa and her department, as it was then as CEO of Sassa, will pay. They will foot the bill in this case. And if you look back at various procedures over Sassa and the crisis at Sassa, for example, that very widely publicized Section 38 inquiry under retired Judge Bernard Ngwepe into Batabile Dlamini, all the parties there, including Thokozani Magwaza, who was a CEO at Sassa at one point, and Zane Dangor, who was at one point an advisor to then Minister Batabile Dlamini, their legal bills were also paid by government departments. So government's racked up a very significant bill through various legal procedures connected with the Sassa social grants crisis.
You were saying earlier, Erin, that former Minister Batabile Dlamini gets off scot-free here.
She does. So when this order was handed down in March of this year, on the 23rd, the court suggested that Dlamini and Bhengu both provide affidavits or statements to the court on why they shouldn't be personally joined to this case. And this case, it must be emphasized, is only the case over the extension of grants payments in cash. So the extension of that CPS contract for social grants paid in cash. They then made those submissions, and today's judgment is about costs for that application, and they've only ordered that Bhengu and Sassa pay in professional capacities, not in personal capacities, even though Dlamini was up for consideration for paying personally in this case of earlier this year. But I think what a lot of South Africans are keen to know, and in fact there had been some reports that today's judgment would be on that, is whether or not Batabile Dlamini, now Minister of Women in the Presidency, is going to be held personally liable for costs over the broader social grants crisis. And this follows that inquiry headed by Ngwepe, involving many hearings during which, as is her right, she spoke in isiZulu, made repeated denials, answered questions with questions, was a really poor witness witness on Ngwepe's version, and he filed that report with the Con Court back in April of this year. She had right of reply in May to argue why she shouldn't be punished personally with a costs order, and that's the last we hear of it. And I really pressed officials at the Con Court this morning for some idea of a date, because I think it is a matter that is certainly in the public interests, but we've had no answer on when we can expect that judgment.
All right, well, thanks very much for that update. Still no answer on that very important decision, in terms of Batabile Dlamini and whether she will in fact be held personally liable.